So today at the conference we have discussed the effects-based approach to Article 102 cases, i.e. abuse of dominance cases, especially through exclusionary conduct. And in that we tried to compare the benefits, if there were any, of the form-based approach, which perhaps admittedly brought in some legal certainty into the gameplay through bright line rules, but at the same time it was relying on too many presumptions, obviously. So by discarding these presumptions, did we do well, or did we open up the whole sphere of exclusionary conduct enforcement to certain issues of evidentiary burdens? Is it too tough on the antitrust agencies now? Could there be a balancing act? Then we discussed in that capacity the new guidelines that are going to come in and the amendments that have already come in, what they mean. In the same capacity, we have discussed the as effective competitor test. There is a virtue in protecting competitors that aren't as effective as the incumbent, obviously, and no one in the room disputed this, but at the same time, when judging the economic rationality of a conduct of the incumbent that has market power, shouldn't you judge whether that act is lawful or unlawful through an understanding of where the competitors are? Is the competitor being driven out of the market through competition on the merits, or is the competitor finding itself in a certain situation because of an artificial conduct of the exclusionary conduct of the incumbent? And in that, obviously, not all exclusionary conduct is harmful to genuine competition, so there will have to be a differentiation in that sense as well. We tried to look into the policies and principles that may enable us to better distinguish and to better provide legal certainty to the incumbents that have market power.